that in this particular case, when there's a failure to refund client fees, is malpractice. But also, I guarantee you, it's going to be an ethical issue. We were talking about this the other day. In the old days, and John and I were arguing, ethical rules were guidelines. Disciplinary rules were mandates. And if there was a mandate where you didn't do something, then that is a presumption of malpractice. Ethical decisions, that was not the case. We now have professional rules that have put the two together. A violation of the rules of professional conduct do not by itself prove that there is a legal malpractice action. You must have the nexus connecting damages. You must have proof that it is beyond the standard of care. Must admit, pretty easy case on liability. But the fact is, you still need that testimony. You can't just say, oh, because the ethics committee sanctioned him, that we're going to use that. That ain't going to work. And quite frankly, I think some of it would be prevented from coming into it because that's a police power of our bar association. I sat on the committees numerous times listening to cases come in. I was just horrified, wondering why didn't these clients sue this person? You know, it just shake my head, but clearly we needed to go forward with what we were doing in sense of suspension or disbarment. But you still need damages is what at the end of the day that comes down to. Another example is a negligent drafting of a legal agreement. Got this pending case right now. An attorney named withheld went ahead and prepared a cognovant note, and the terms kept changing, so she said, cut and paste it. Next thing you know, the warning paragraph ended on a different page than the signature paragraph. I don't know how many of you have dealt with the commercial notes, what a confession of judgment is, but it requires and mandates in bold print, larger than any other print, a warning that if you sign this, a lawyer can appear in court and confess your judgment without you being there immediately, upon default, of course. And so it ended up on another page. Of course, the business owners failed to pay. They go in to go ahead and file a collection activity, and the collecting lawyer looks at it and goes, uh-oh, this is no good. Now, it doesn't mean the note's a bad note. It just means you can't take a confession. They spent 1.5 years in court while the buyers milked it, ended up filing Chapter 7 bankruptcy. And so an opportunity for a judgment to get an immediate receiver to take over that business, pretty high. In worst case, 30, 60 days. What judge is going to try the entire case when somebody has defaulted for the failure to pay a note? You're going to have some really good juice. And that might mean a separate claim, but the receiver's still going to take control. And at least your asset doesn't go down to you-know-what during the interim. So be very careful on drafting these notes. I have seen time and time again where people say, well, I walked down the hall and asked one of the other lawyers in my office if he had a form for that. Really? I took a deposition of a defendant in a legal malpractice case probably two months ago now, and I asked him what he did in order to look up the elements of the case that he filed suit on. He missed the statute of limitations, was claiming there was an act of conversion. I said, really? Okay. What's conversion? Tell me what it is. Well, he tells me what it is and on a global scale. I said, do you know there's a statute on that? Do you know what are the elements necessary to prove a conversion claim? Did you do any legal research on that before you told the client she had a viable claim for conversion? No. My mouth about dropped. I couldn't believe it. I don't care how elementary it is. Every single case I get, law can be updated, case law can change. If you think we know it all, no, we don't, because it's a liquid career we're in. Look it up. What are the elements that I need in order to prove this? And it just is amazing that some lawyers just don't do that. Mentors, I think it's very important to have a mentor if you're not qualified. I do see, I had a case just last year, we ended up settling it, where it was over a qualified domestic relations court order. Actually, this one was a DOPO because he was in STIRS, a teacher's retirement, where they went ahead and the individual didn't get survivorship annuity benefits. If any of you do DR work, that's the first flag that you throw up, because if the guy dies, bye-bye, goes pension. So it's pretty normal. But this attorney, a younger attorney, not younger in age, but 6 years out of school, failed to advise the survivorship annuity. And her defense was, well, she read the form and didn't check the box. Well, I've had lots of clients that aren't sharper than the lights, or the sharpest knife that I have in the tool, or the lights on out the thing. You have a duty to tell them what that means and what happens if you don't check that box and pay for that premium. So again, knowing the elements of what you're pursuing, get a mentor if you don't. This Deutsche Bank case is really interesting that I attached too. Deutsche Bank was a mortgage foreclosure action that targeted law firms who targeted people in foreclosure actions, saying, hey, give me $850 and we'll defend you because we're going after these guys. These guys, they're fraudulent and they're selling their notes with robo-stamps on it, blah, 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 blah. So it gets into the fact that they take their money from hundreds of clients and don't do anything. And then there was a malpractice action as a result of it, not on negligence, that was one of the claims, but on a civil conspiracy fraud, that you were collectively targeting a class and covertly did actions to invite us into that arena and then failed to do anything after you took our money. Through summary judgment, it was dismissed in the trial court, dismissed in Court of Appeals. Supreme Court said, no. When these people are engaging in a scam to prey on foreclosure defendants, in which little or no services were provided in return for an upfront fee for assistance, that is grounds for a legal malpractice action. The thing that was interesting here, and by the way, this case talks about how the violations of professional rules are not necessarily give rise, however, they're guidance too. But the key is what damages flowed out of that case. But they said a civil conspiracy action is on acts that are beyond the attorney-client relationship. And that's interesting. You don't get to see that very often. But with the mass advertising that's going on now, you may want to look at that if somebody's coming into your office on a case, just to make sure you're covering yourself. We certainly want to be due diligent in everything that we do. Having sat on the committee for 11 years, they now require any more than 10 years. The Supreme Court, in their infinite wisdom, said that you got to sit out now for 3 years. So I got my Dear Jane letter 2 years ago, and I for the life of me, I don't know why, because we're the ones that know more than everybody else because we've been on the longest. But irrespective, through all my years of sitting on the committees and doing legal malpractice cases, it is absolutely amazing to me the extent of bad practice that sometimes isn't quite malpractice. And I'm anymore pretty much drawing a line in every profession. A third, 25% to a third. People are lazy. People are greedy. People just don't care. They're not professional. I see it all the time, and it's certainly concerning to me. But some of the things that what you need to look out for in a legal malpractice claim I've illuminated on page 2 is you may have an error in law. Somebody may just not know the law and say, yes, you can do this, or no, you cannot. Those are substantive issues, so clearly your expert would have to testify about those. You can have damages issues where somebody failed to have a forensic accountant come in and testify, or a life care plan to come in and testify, and loss of consortium damages out the window because nobody developed it. So you have to have, again, supporting expert testimony to prove your damages that flow. Drafting errors, we've talked about that. Procedural errors. I've seen people file things that get the cases dismissed. Motions to compel discovery, you don't answer, it gets dismissed. Ouch. You know, those things can get expensive to the attorneys if it doesn't happen appropriately. Statute of limitations is a big one. I told you that before, probably. Lazy, number one, and just not working a case and going to trial and shooting off the hip, not prepared, is 1A and 1B for missing statute of limitations. Those are most of the cases that we see with lawyers coming in the door in trouble. Obviously, we talked about billing errors, and overcharging the client can be something as well. In the Roman numeral number 4 now, we're dealing with the statute of limitations. It's still 1 year for lawyers, less like we talked about otherwise. The Daniel versus McKinney case does a nice job of illuminating what establishes an attorney-client relationship. I'm going to jump. I attached to you, like I told you earlier, my files are thick because I've been through this arena of ethics and legal malpractice. I'm probably thicker than anybody's out there because I document everything, and I ask for consent almost to any move I make. And anymore, it's kind of easy when you got these things in your iPad and you can just take something from the attorney, ship it to the client. Is this okay? As simple as that. If they ask you a question or you need to set up an appointment, come on in. If you need further elaboration. But getting consent to strategical points I think is critical. But the most important is the statute of limitations. I attached to the documents here, it's not quite the very last thing, but it's a letter. And it's a letter that I send to, it might be the last thing, to clients at the end of the case. This one here dealt with a rather quick nosedive of the case where the expert came back and said, you have no case. Fine. I'm sending a letter to the client telling him, here's a report, you don't have a case, appreciate your business. I'm closing your file and terminating your attorney-client relationship. How definitive is that if somebody comes back to you in Dick Hunt's case 14 months later? You have in writing a document that states that clock starts ticking now. I also cite therein, to try and smooth that over, the right of them to get their file back within 7 years.